Who's in charge of the jury instructions for each side? I know everybody can talk to each other, just so I can know who I'm talking to. Pribble, are you doing the jury instructions? Ms. Howlett? Who? Okay. So how I like to do this, just do a flyby at first, just kind of the easy ones. If I, Ms. Howlett, you want? No problem at all. Dunk, could you move that screen back so I can see Ms. Howlett? I got four or five of them here. I want to wait on those. One of them's easy in my opinion. And so let me just go through the packet here. And if I don't hear anything, I'll assume that's no objection. If you have an objection, let me sing it out. So 3.1, Introduction to Final Instructions, standard. 3.2, Statement of the Charge. 3 counts of first-degree murder with a firearm, attempted first-degree murder with a firearm, and grand theft motor vehicle. Looks appropriate. 3.4, when there are lesser included crimes. So as to the first 3 counts, first-degree murder with a firearm, the lessers would be second-degree murder with a firearm and manslaughter. Under the attempted first-degree murder with a firearm, all I see here is attempted second-degree murder with a firearm, and then there's grand theft. Defense, are you requesting any others?
I'm just going to write. I have a copy, so I'm just going to write.
Those are complicated, though. There's a lot of different, for the manslaughter, I'm sorry to interrupt. For the manslaughter, you know, there's different sections of the manslaughter.
Attempted first-degree manslaughter is a very tricky.
It is.
The law is tricky.
It is. So I think it's best that we ask the defense to kind of draft out what they have in mind, maybe.
Okay. I think that's reasonable.
There's so many different things you can
all right.
cross out.
She said okay. So you do it and we'll take a look at it later. Okay. But you don't object to them getting it?
No.
And Ms. Howitt, as an officer of the court,
If it fits their instruction, how they draft it.
Sorry, Judge, we were talking about perhaps instead of attempted manslaughter going with the aggravated assault that is already attached.
that would be a lot simpler and a lot less risky. So unless I hear otherwise, we'll make it attempted. No, it would be ag assault with firearm, correct? And then that would be it. Then you're satisfied with the lessers that are being given. All right. 3.5, principal instruction. That's the standard instruction. I know Mr. Pribble has something else to it, but I want to just do a flyby, and then we'll talk about the specials. So 3.5, principles, we'll talk about. Independent act is in here, but right now that would be inappropriate.
I knew that when I spoke with defense, they were asking about it, and I'd rather just go ahead and put it in. I didn't know what was going to come up.
Okay. Right. What's that? Okay. All right, we're going to have a separate legal argument on that later, but I've been up here studying that specific law and the cases that go along with it. And at this juncture, I don't think it's an appropriate instruction to read in this case. Now, always starting with the premise of if there's a scintilla, that might be a strong word, but if there's any evidence of a defense, you always err on the side of reading it. However, I want to hear some legal arguments from the defense how that could be appropriate in this case, because there has to be a common plan, and almost to the point that an admission that there was a common plan to carry out some crime. And there has not been any type of discussion of an admission or any type of plan or agreement to a plan that then the defendant, Mr. Vasata in this case, says somebody else exceeded our plan. So I'll give you some food for thought, and we'll address that later. But for right now, I'm going to pull it aside and take it out. Introduction to homicide, 7.1 is a standard instruction. So it looks appropriate, and it's got excusable homicide, etc.
We would object to paragraph 3 under excusable homicide, since it really does not apply to
believe that, and I could be wrong, but I think the case law regarding this intro to homicide stuff is you don't touch it. That, you know, the excusable, the justifiable, I don't know that they can waive that.
Ms. Howlett, you want to respond?
It is our position that it is not appropriate in this case, and we will object
We can do some research over lunch. I can't remember what case it is. It's just,
All right, I'll let you do some research, but it's paragraph 3 under the excusable homicide, am I correct?
to it.
All right, I've got it circled, and we'll talk about it. Murder first degree. Anything in there, Ms. Howlett, that you object to? Keeping in mind, this is really just a preliminary, I don't want you to feel like I'm rushing you. Okay?
On all of the first degree murders are not right here, but we'll get to them. Is defense asking for this adequate provocation?
In the heat of
In
passion.
the heat of passion,
we would object to that. It's not relevant.
at the bottom of first degree murder?
I'm sorry, I didn't hear that.
The adequate provocation, heat of passion, I think that comes out. Okay.
Did she agree that it comes out?
No,
Right,
No.
and did she agree that
Oh.
they want that? We don't think it's relevant.
And are you specifically speaking of the paragraph that reads, "An issue in this case is whether Christopher Vasata did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation," then there's a list of things here.
yes.
Unless I see some case that says otherwise, I think that's appropriate to read in this case. So I'll wait.
Judge, I would like to address the meanings of the parties that are contained in this as well as throughout. I don't believe that middle means that you use.
Do you care? Okay. Second degree murder? Anything, Ms. Howard, that you want out?
Yes, okay. Is that okay with Your Honor? We're going to change the names to make them just first letter capitalized.
Hold on, sorry.
It's all right. I've learned to slow down on charge conference and jury instructions.
I think it is appropriate instruction.
All right, so second degree murder instruction looks appropriate. And then manslaughter.
Hold on, sorry, that's a section.
Okay.
On the instructions, first of all, I'm sorry, Judge. Back on murder, first degree murder, we believe that interrogatories are appropriate on that count as well. And so their language.
In regards to carrying the firearm?
Yes.
Well, I think that there'll be interrogatories on that. Did he?
Okay. So
I
I
think
just
it's
want to be clear,
smart.
'cause they were not in on the
Yes.
first, they are in on the second degree. So, and they're.
They'll be added.
You'll add it? Okay.
There's also, some language issues here. And that is.
Are you on first degree, second degree, or manslaughter?
Second degree, because it's the only one that has the language for the interrogatory.
Oh, okay.
Manslaughter should have the interrogatories as well.
Sure, each one of them should.
Should they have the same interrogatory?
Yeah.
Okay.
Yeah.
Okay.
Sorry.
And Ms. Howard, are you on manslaughter or second?
I'm on second,
All right.
and so the next to the last paragraph,
Read it to me, the start of it.
if you find the defendant guilty of second degree murder and you would if you also find.
Yes, I'm with you.
So I don't even know that that
What's the harm? I mean, if you want it in, it just is going to track the interrogatory anyhow.
Well, it's not, this is a different interrogatory, this is not the 10-point life interrogatory. This is just second degree or second degree.
And what's your problem with that part of it?
Well, first, it's not, the first sentence doesn't make any sense.
If you find the defendant guilty of second-degree murder and,
Yeah, I got that, and if you also find. Oh.
And so, the verdict form does not reflect that option. So,
Could be added on the verdict form. Yeah, the commission, the carry, display, use, threaten, use. It's there, isn't it?
it's in the instruction, she's saying it's not in the interrogatory?
It is.
the interrogatories are all inconsistent. So, Judge, it's a little hard to do this without discussing the instruction with regards to that we have submitted, because I think that plays into the interrogatories.
Okay.
That is the issue of, and I think that's my concern about how it's laid out here, is
All right.
it's confusing this aspect of it, the carry, display, use, threat to use, I believe. That determination, the principal instruction does apply to, whereas the principal instruction does not apply to the 10-point life.
Well,
So,
let's talk about your special instructions then. Modification for the standard instruction for rules for deliberation. Have you had a chance to look at these, State? Mr. Pribble gave me 4 separate motions, and one reads, motion for modification of standard instruction on rules for deliberation. I started with the easy one first.
okay, no, I was only talking about the principle, because of how it plays into the interrogatories, so.
Okay.
the rest of it is about
Yeah. Judge, I don't think we're ready just yet.
All right. Okay. Make sure you have the 4 motions that the defense has put forth. Take a run through your jury instructions during the break, and we'll reconvene at around 12:50, and we'll have some discussion about how we're going to proceed from a scheduling standpoint, and then we'll figure it out from there. Okay, we're in recess.
Stand on that.
Judge, we've been texting him to assist the defense in.
I didn't ask for assistance, I had him under subpoena.
Oh, okay, easy does it. Easy. I'm not so sure what the relevance is of, it's Narcisse Antoine. I remember it. It was a very intense moment in court. I have a distinct recollection of it. And I got reversed. I know that as well. But as you could tell, I don't take those things personally. It's just somebody else's opinion. Although that was a jury instruction issue as well, and that was part of it. They found 6 different grounds to make me look not very smart. I didn't think it was so hard to do. Anyhow, I guess the commentary, I don't think it needs for me to respond. You can call him, not call him, and I think both sides have the right to talk to him or not talk to him. So without anything further there, then, okay, you're not going to call them. And then how about the rest of our issues, and what would you like me to do? I'll listen to both sides, and
I think that we need to have, Mr. Harrington here for those records.
okay,
So I don't think he'll be very long,
okay,
but I would like him to be here to talk about the time, because there's a time difference.
that's your prerogative.
And then we'll be done.
Okay, but I'm going to take it my prerogative to schedule it the way I see appropriate. Because what I want to do then is also then read the jury instructions to them. So we knock that out, and then we're right where we planned on Thursday morning. So I'm going to talk to the jurors.
Do we need to question Vasata about his right to testify?
Oh, right, thank you. So, Mr. Vasata, you remember it seems like a long, long time ago. I said I would turn to you and ask you if it was your choice to testify or not to testify. And I think by what I heard from Ms. Ramsey that after Harrington, there'll be no further evidence, and it is your position. You're going to follow the guidance of your attorneys. You understand, just speak up a little bit, not to testify, but you understand that it is your choice and you're following their advice, but ultimately, it's your call. You understand that? Okay. I'm not trying to give you a hard time, just I think the law requires me to do that. And so I think now what I'm hearing is they're done for the day. Okay. And then tomorrow I'll talk to them about they prefer to come in the morning. It'll be later in the morning I'm going to propose so we can get the jury instructions completed, or even after lunch. So I'll bring them out and try to get a consensus from them. Does anybody have an objection to me laying this out for them and then let them go back there and talk about what they prefer? No objection. No objection. So I suspect the testimony would be half hour total? An hour? Max an hour. And then I think reading the jury instructions will take them almost 40 minutes, I would suspect. All right. And then we would release them and have them reconvene at 8:30 on Thursday morning to do closings and begin deliberations. We'll also maximize our time, Dunk, by tomorrow giving them menus to place their orders for lunch on Thursday, just to make it feel like we're filling up their time. Anything else before I bring them in you can think about that I need to address?
The only issue that I have, and it might not be important for this moment, but my understanding is the court's intention is to read the instructions well in advance of everything, which I don't have a problem with. What I would ask the court to do, and this packet is many pages of instructions, there are 4 pages of those instructions that are substantive instructions. One pertaining to 3.7, plea of not guilty, reasonable doubt, and burden of proof. 3.9, weighing the evidence, and 3.9a, defendant not testifying. I would ask your honor to read those after the state's rebuttal argument prior to sending the jury to deliberate.
Well, I never do it that way anyhow. And listen, I'm going to give them a packet. Each one of them is going to have a packet, so I'll deny that request. Let's bring in where'd Dunkley go? You went to go get him? And Ms. Ramsey, do you have any objection to me telling them that tomorrow, whatever time they come back, that what the defense is going to do is call one witness and then the defense is going to rest as well? Okay. And it's Harrington? Is he a detective? Officer Harrington, I'll go with that for now.
Judge, I made a few changes over lunch. I gave a copy to defense, just so you all are working off of what I'm working
A
on.
fresh new packet for me?
Yeah, just kind of in a little bit of.
Bring it on up. I'll dispose of the other packet.
I'm making changes. We're all looking at the same thing.
Thank you very much. Everybody's ready? Let's bring them out. Please. All right, everybody have a seat, make yourselves comfortable. So jurors, I got to talk to you for a minute. I got good news, I got bad news, I got kind of in between news. So I got a lot for you to talk about. So, 382. Okay. So a lot's happened since May 31st, and as I've told you many times, there are a lot of things going on. Plane rides, FedEx packages, all sorts of things happen while both sides are working really hard to get things in order. And you may not see it, and you may say, golly, how's this happening? Well, trial work tends to be that way. Things happen, and people respond to what happens in court and all sorts of things. So I know that your time is valuable, as I mentioned at the very outset of this case, and I'm very respectful about that. But some things I can't help. So we are at the very tail end of the case, the very end. I'm being told by the defense that they will be calling one witness, Officer Harrington, from Jupiter PD, and then they will be resting. Okay, so we'll be done with the presentation of evidence. And the thing is, we're not ready to do that right now. So shortly, we're going to be done for today, and I know that you spent time at lunch, and we don't know sometimes how these things are going to go. But we are at the end of the case. We are exactly on schedule, if not a little bit ahead of schedule, if that makes you feel any better. I have a question for you all as a group, and I'm going to send you back into the jury room to talk amongst yourselves, to tell me what you want. If you can't reach an agreement, just tell me 10 of us want this, and you'll get the idea where I'm going to head. You are not deliberating. You are not deliberating about the case. You are not to pick a foreperson. You just have a discussion. And here's the discussion I want you to have. We have one witness left, one witness that we think will take no more than an hour, maybe as little as a half hour. Then I'm hoping by that time that I'm going to have a packet of jury instructions ready for you. This is the preliminary packet right now. I have to read it to you. It's complex. We will be giving you a copy. It's complex. We're still working on it. So this afternoon when you go home, we are going to stay here, and we hope to have this packet good and ready. So we're going to have one witness. Then I'm going to read the packet. We're going to give you menus to order food for Thursday, and then you'll be done for the day. Thursday, we will come in promptly, 8:30, right into closing arguments, because I have already read this to you. Closing arguments, I told you already, 2 hours per side. The state will go for approximately an hour, hour and a half. They'll sit down, then the defense will go for 2 hours. And all this is approximate. Then the state gets last words. So whatever time they had left, they'll give the last, let's say it's an hour and a half, they'll go 30 minutes, and we'll be done with the presentation of evidence, and you'll begin your deliberation over lunch. So my question for you is this. Tomorrow, since we have one witness, read this and order your food. I want you to go in there and talk to me about when you'd like to come back to do that. If it helps you all to come in at 9 o'clock in the morning to do it, we'll do it at 9 o'clock. If you say, Judge, I like to go to work and come here at 1:30, that's fine as well. I want to do whatever works best for the majority of you. I can't please everybody. Hopefully you all come out and just tell me boldly, this is what you want to do. So tomorrow, one witness, packet, menu, done. Question for you is to come out and tell me in a minute. We're going to put you back in there. You're not deliberating the case. You're not to talk about the case. Just simply what time you want to be here tomorrow. That's it. For about no more than 2 hours worth of work. Probably closer to an hour and a half. Done? Take them on back. Turn your pads upside down. When you're done talking amongst yourselves, knock on the door. Tell us. That's them.
That might be bad omen for either side.
I don't know what took you so long. When do you want to come back? In the morning. What time did you say? Everybody can have what they need, 8:30 tomorrow? Same drill. You got it. I promise you I'll do whatever you want. 8:30 it is. Any other questions? Don't talk about the case. We're so close to the end. Don't Google, Facebook, don't read any newspaper, watch any television about this. And I'll see you back tomorrow morning, 8:30. Leave your pads there. We'll collect them and store them up. Thank you for your patience. Don't rush. Take your time. All right. I guess we get to work then. I think based on this morning's conversation about this, maybe we should start with the special instructions then. Does that make sense to everybody? Okay. I want to start with the easy one. Motion for modification of standard instruction, rules for deliberation. And the suggestion is basically tell them not to get in a fist fight, and the same instruction I gave about the photographs. Did I capture your argument?
Yes, just to include the instruction you already read about the images.
That's what I said, the photographs, and don't get in a fist fight.
I don't think that that's a fair characterization of what I'm saying.
Well, I'm going to grant your motion. And so if in the course of deliberations, anyone attempts to intimidate, bully, unduly influence, coerce, or threaten you, don't get in a fist fight. Don't get in a fist fight. Regard the photographs. Where do you want those inserted? Talk to the state. Your motion's granted. Where do you want it inserted in the instruction? I'll let you two work it out.
Just for the record, the attached instruction would be exactly how I would ask for it, just to add in paragraph 8 and paragraph 9.
I didn't see it tacked there. Looks fine with me. So rules for deliberation 3.10. First part of it is standard. I'll add 8 and 9. That takes care of that. Ow. Mr. Pribble, from your perspective, which one would make the most sense to take next?
I think that pretty simple one, is the motion for special jury instruction, setting out the burden of proof as to principles. Also has a memorandum of law.
Yes, okay,
And I think the argument's more simple than maybe the length of the motion might
All right.
indicate, but just as every other element for any offense, it requires proof beyond a reasonable doubt. For whatever reason, the standard instruction does not say beyond a reasonable doubt, but I can't imagine what other standard there is that could apply to that instruction. So I think absent the instruction saying beyond a reasonable doubt, we need to put that in there, just like we would for any other offense that has elements.
State, what do you say?
You know, I've read the law that Mr. Pribble has attached. I would leave this one particular motion up to the court. I mean, I think the law does lay that burden on the principal theory.
What do you mean by that?
That the case law that he cited, Douglas, Ray and Lazari, they talk about, you know, they don't specifically say you should read it in the jury instructions, but that we do have to prove beyond a reasonable doubt the participation of the accused in the crime, whether it's from direct or whether he's a principal. So I don't really think it matters one way or another.
Okay. Because I'm acutely aware, based on Narcisse Antoine, about the necessity to give special instruction when there isn't one. And in that case, I looked back at the opinion after it came out and said, how did I miss that? When I let it into evidence appropriately, some folks wouldn't. So I got that part of it right. And how I missed that I should have given an instruction there. You look back and you're rushing and you had a lot on your plate and it was a fairly contentious trial, my recollection. I said, man, I blew it. I disagree with some of the other bases they used to reverse me, but I really said I was wrong. I missed it. The difference here, Mr. Pribble, is that there is an instruction. I wish the Supreme Court, they keep telling us to be magicians here. They give us instructions, and then they tell us, wow, you should have massaged that instruction. When, as opposed to there isn't an instruction, and I should have given one. But what I'm hearing the state saying, it's an accurate reflection of the law.
It is, I think.
And the way that Mr. Pribble has suggested the language meets with your approval,
Yes.
then I'm going to read it. There you go.
The only issue with it is that it would apply to all of the offenses, and as it's currently drafted, it talks about a principle to the crime of. So I don't know if we want to put just principle to the crimes charged, or if we want to say specifically principle to the crime of, and then enumerate each one.
I would prefer as to the crimes charged.
That's fine.
Okay, all right.
I would use that.
And what about motion for special jury instruction regarding applicability of principal theory to interrogatories?
Judge, I'm sorry, state objects, I don't even understand their proposed instruction. It's confusing. Special instructions are for areas where, you know, there's confusion or silence on a topic. The way the instruction that they're asking for is drafted, I've read it 3 or 4 times, it makes no sense. And it just causes, I don't even know what it means. It causes mass confusion. So we object to it.
So I am very open-minded about changing the language of it, but if I could just be clear about what problem we think there is, it needs to be addressed. And so there's 2 different types of interrogatories that are going to be in play. One of those is an interrogatory 475.087.1, and that is the enhancement statute for carrying, using a weapon during the commission of offense. And I don't think we need any additional guidance as to that, because I think the case law says that the principle isn't really an issue with that. But when it comes to the 1020 life interrogatories, the third interrogatory regarding whether Mr. Vasata discharged a firearm and whether Mr. Vasata's discharge of the firearm in his possession was what caused the death or great bodily harm to the named victim of that count, I think is an area that could potentially be confusing to the jury, because depending on what they ultimately believe about the facts of the case, they could determine that there were 3, even 4 people present. They could determine that there were 3 firearms present. They could determine that at least 2 of those firearms were discharged. And although I think the evidence is probably fairly clear as to 2 of the decedents as to what firearm they were shot by and killed by, the risk is that a jury, let's say, is looking at count 1, is making a decision about whether Mr. Vasata discharged the firearm that resulted in the death of the named victim in count 1. If they're also thinking about how, well, there was a discharge in count 2 by another individual that resulted in the death of the named victim in count 2, I think there's a risk of confusion as to how to apply that. And so I had a case in front of Castronakis where there was 2 co-defendants. There was initially only an allegation of 1 firearm, and if he had given an instruction saying that principal theory doesn't apply to the interrogatories under the facts of that case. In this case, the only instruction we would want is directing them that the interrogatory regarding discharge and great bodily harm or death as to count 1 must be answered by determining if the defendant was the one that discharged the firearm that resulted in death to the named victim in count 1.
And Judge, just one more thing from the state. Those interrogatories, the 1020 lives, that's, the main purpose is for the courts in sentencing, not for the jury in applying 1020 life, but for the court. So if the court at the end thinks there's an inconsistent verdict or something, then the court just wouldn't apply that 1020 life. But there's multiple shooters in this case. The MEs aren't able to tell specifically which bullets did the damage to each individual victim. And so under the principal theory as well as direct evidence theory, it'd be the state's argument that Vasata was guilty either way.
Mr. Stone, let me ask you a question. Do you disagree with the law cited too by Mr. Pribble that says the principal theory does not apply to the interrogatories, though? I think he cites the State v. Rodriguez.
To look it up if I could.
when a defendant is charged with a felony involving the use of a weapon,
What's the site? I'm
it
sorry.
is 602 Southern Second at 1270.
12-7?
1270. 1270. Yeah.
I just think that we wouldn't have the interrogatories if the principal did it, right? Isn't that the whole purpose of the
I think that's what the law says. I'm just giving her a shot to tell me otherwise. And then what is, that's just one step of the analysis. I think that's pretty clear. That's why you have,
I agree with that.
so you have to say, he may be guilty of first-degree murder, but to answer the interrogatory, that he actually possessed the firearm, that it invokes these other sentencing requirements, et cetera, they have to make a finding that he actually possessed it. Would you agree that's the law?
I do.
Okay. The question is, how do I deal with this issue? I'm not so sure I like the instruction that you've proposed, and I'm trying to think of another way to deal with the issue. Meaning, could we adjust the interrogatory?
It's confusing because of the facts of our case. I know it doesn't help you, but it's not like we're charging the getaway driver and we know exactly who went in the bank and killed somebody. So I'm not quite so sure how to draft that. Is it not? Right, I mean, doesn't it but does it say actual? I think, Judge, if we look at the language, I mean, the language in the interrogatory itself lays out, you know, question one, during the commission of the offense, did the defendant discharge a firearm? I mean, it's asking, did he actually do it?
But the problem is the principal instruction and.
Which applies to the crime
Right.
and not to the interrogatory. So I thought to myself,
I know.
so under the KISS theory, you could just adjust the interrogatory.
Is it just, okay, so are we talking about adjusting just that one? Because the other two speak directly to,
I just think it has to be clear that the instruction that says he has to be treated as if he had done all the things somebody else did does not apply to the interrogatory. So I'm just.
But I'm afraid, I don't mean to interrupt, Ms. Howard. I'm afraid if we say that, then the whole interrogatory, if you think of it, they make it confused and go, well, it says guilty of first-degree murder. So, I don't know, first of all, they're not gonna know what an interrogatory means.
Right. No, that's why I wouldn't use that.
Yeah, so I think, I mean, would it cure it if we said during the commission of the offense, did the defendant actually discharge a firearm? Was the person?
Now you're reading my, that's what, I was gonna say, actually, or himself, actually,
Personally, actually.
something to adjust the interrogatory that makes it clear.
But is that going to confuse them about guilty or not guilty of first-degree murder without an explanation?
I don't think so. If we're adjusting the language that comes at the end,
Technically, we don't,
it has to be.
but we're still going to see problem numbers.
If you find committed
We
first degree murder,
don't have to.
also find discharge the firearm.
How about,
There was, in the case that I told you about, this issue sort of came up, on the principal instruction, there was, the judge included a simple line saying, the principal theory does not apply to your determinations. I don't remember the language, but it doesn't apply to the interrogatories. And of course, you could word that in a way that would be more clear. But if you did that and you tailored the language of the interrogatories themselves to say personally discharged,
Or if you, I'm just thinking, under guilty of first-degree murder, that's when you would say it. It'd say, now the following three questions, the principal theory does not apply, right? Because if you think about it, interrogatory is the entire verdict form. So I just don't want them to get confused to think principal does not matter
I
or
want it to be-
apply to the guilty of murder.
I totally agree, and nobody wants it to be confusing. I think you're on the right track, that if we're,
Right there, after, if you find the defendant guilty of the offense, you must answer the following four questions. The theory of principle does not apply to these four questions.
how about that?
Am I talking too loud?
No, just too slow, too fast.
What did you just say? I don't know what I said.
How about that?
I still think it's going to be confusing to them. But that's what lawyers are for. We can try to clear it up in closing.
And I was going to say that, but I'm just slowing down here.
Right.
This is a tricky, tricky area. And I think if we can include some language that's not offensive to either side, it would just help us make it more clear.
Your Honor, in my experience, when the judge explains the verdict form to the jury and says, you're going to go through it this way, you would instruct them that the interrogatories for first-degree murder, you don't even look at those or decide those unless and until you've found the defendant guilty of first-degree murder. So just in terms of the state's concern that they would be putting the cart before the horse and saying, well, they say principal theory doesn't apply to this, so therefore it doesn't apply to the defense. I think if you just are explicit that the interrogatories aren't even addressed for any offense unless there's been a unanimous finding by the jury that there's guilt beyond reasonable doubt as to that offense.
Me explaining to them doesn't make me feel safe, though, for review, so.
The other solution is that, I don't think I like that solution, sorry.
How about this?
Withdraw that.
Guilty of first-degree murder, the firearm is charged in the indictment. If you find the defendant guilty of this offense, you must answer the following four questions. In parentheses, the principal theory does not apply to the following four interrogatories. And then you answer, during the commission of this offense, you ask, during the commission of this offense, did the defendant himself actually discharge a firearm? Number two, during the commission of the offense, did the defendant himself actually discharge a firearm? and so on and so forth. So you're telling them up front, right at the very top, the principal theory does not apply to these next 4 questions. State, what do you think about that solution?
I know, if I can.
Take your time.
That's fine, Judge, I think.
So it read, guilty of first-degree murder with a firearm is charged in the indictment. If you find the defendant guilty of this offense, you must answer the following 4 questions, in parentheses. Could you say the last part a little louder?
If there's no enhancement on first-degree murder, we don't need number 4, so it's
Okay.
Is that right? You were correct in her.
That's fine. I mean, we really didn't even need interrogatory for this. We need them on second. Yeah. Okay.
We're on the same page?
Yes, but now we have to go back to the actual instruction.
Which instruction?
On the murder instructions as to the elements.
Okay.
And we don't have the interrogatories aren't included yet on the first degree murder, they are included on the second degree murder. So that's
Okay.
what we're looking at.
Okay.
Got it?
Nope.
Okay. Second degree murder.
So you want me to flip to the actual second-degree murder instruction? Okay. I'm there.
Second page.
Second page.
So I would say that it should read that he himself or he personally possessed a firearm.
Are we, okay. So the second paragraph on the top?
To have the language consistent with the interrogatory as I proposed it. That,
On the second degree murder, you said?
correct?
Yes, only because you're going to ultimately put those same interrogatories on the first
Tracking.
degree murder.
Okay. So the, and you also found beyond a reasonable doubt during the commission of the crime he possessed a firearm. That's what you're talking about.
Right.
And so we're saying the language.
He himself actually possessed a firearm.
Yes.
I don't know grammatically, that sounds.
I was going between himself and personally, but I think himself is more clear.
Okay.
During the commission of the crime.
So he himself
The
actually
defendant himself possessed a firearm.
That's better. The defendant himself actually possessed a firearm.
Sure.
That reads better.
Good.
Got the defendant himself.
Yep, so I'm gonna put during the commission of the crime, the defendant himself,
Actually.
Actually.
possessed a firearm.
Hey, Mona, if you're back there, will you come in here, please?
So that would also be true on the next 2 paragraphs.
Okay, so the next two, and it'll just read, actually himself discharged,
Uh-huh.
and the next one the same way.
Yeah.
Okay.
And while you're looking at that, Rashay, the
Mhm.
next paragraph, this is just a quick little fix. That first sentence on the fourth paragraph, threaten to use, you got threaten to us.
Threaten to, okay. But I don't know that we need the, oh, this is second degree, never mind, I got it, okay.
It's just a typo.
Right.
No, I was thinking it was the first degree where we weren't just pushing for it, okay.
We all set on that now?
These three to first degree. Okay. Just the, okay. Just these three.
So that typo goes through.
Yeah.
And would the same apply to the manslaughter as well?
No, there's not the interrogatories on the manslaughter, other
I
than
think we need with a weapon.
just the manslaughter.
With a weapon.
It says with a weapon.
Okay, so I added them, I thought. Okay, yeah.
You want it in the,
No, oh, you're right, it's a lesser, right. Yeah, I forgot that one.
Okay, so I'll take those.
are you guys on the same page on this?
Yes, on the manslaughter, yeah. So it's just the one interrogatory for a manslaughter, the carry, display, use, threaten to use.
Yes.
Okay. Almost. Okay, you wanted to,
So I would propose coming back to the introduction to homicide. This would be the same page one.
I'm sorry, I couldn't hear you.
That's right. So with regards to, I would propose that the first sentence on 7.1, introduction to homicide, we in count one, Christopher Vasata is accused of first degree murder with a firearm shot at him. And we do it on the next one in count two, so that it is clear because it's a little
Right,
unclear
accused
to
of-
say
that's fine.
in this case.
Either that, or sometimes I've done,
Or just put that in.
on the verdict form,
And
you
we
know.
should also do it on the
That's
verdict
fine.
form, just a parentheses.
Yeah, parentheses, like count one, however it's laid out in the indictment, you know, parentheses, Sean Henry, count two, parentheses,
just sounds a little weird to say in this case over and over. So
Right.
if we say
So how do you want to say it?
in
Count 1, count 2, count 3?
So in count 1, Christopher Vasata accused of first degree murder with a firearm, Sean Henry. Then we get to do the lessers on that. We'll do in count 2.
So that means reading the entire homicide thing 3 separate times, right?
That's the way you have it.
That's,
I mean, I put it like that because it was standard, but I mean,
it's up to the
ones
defense.
I was gonna take out are things like definitions, say as I previously defined.
That's up to you guys. If you want to try to shorten it up, just tell us, do you want
I
to
mean,
do that?
isn't-
Tell us what to shorten.
Can't you help me? I don't have to read it 3 times. We can make it clear. And it's the same exact thing over and over.
I know.
If you want me to read it, I'm going to read it. I'm never going to get myself reversed for not reading something. I'll read it.
introduction to homicide, the rest of them will read everything, but just this, 7.1, we could just do once.
It's a little tricky because the names are included in it. So that's what I was looking at, trying to figure out a generic way.
You just repeat the first paragraph 3 times.
You could just say in the first thing, you know, Christopher Vasata is accused of 3 counts of first-degree murder with a firearm. Count 1 is related to Sean Henry. Count 2 related to so-and-so. Count 3 related to so-and-so. And then read the intro to homicide, I
I know,
guess.
but
There's other things.
Well, I think the intro, I mean, I think their names are not in the excusable homicide or justifiable
Correct.
homicide, correct? So
Correct.
even if we just did, no, it's Christopher Vasata. Even if we did the introduction, maybe read that one 3 times. I mean, I'll defer to you, but I'm just,
You understand what she's saying? Just as to the introduction, it doesn't have their names over and over again. In the opening paragraph, we just lay it out there. In count 1, charge for first-degree murder of Sean Henry. Count 2, first-degree murder of. Count 3, first-degree murder of. Then read the rest of the instruction.
okay, the rest of the instruction is if you find Sean Henry was killed by Christopher Vasata,
that one can be
we
read.
will then consider. So just give us a
Take me
second
back.
to talk about this.
Like, read this one 3 times.
Right, read that 3 times.
Yeah. This is the only thing else in this is that.
Yeah, go show us.
So where it says,
Yeah, for sure. Yeah, maybe show it to us.
okay, here's what I would propose. Go back to the first place. Introduction to homicide. So we would read the whole thing. We would change that first sentence so it's clear. Now, when we go to count 2,
Are you?
it's always hard that these pages aren't numbered. So,
No.
you got it?
Just go on. Are you talking about on the instruction or on the actual?
I'm talking about
I mean,
the
the
next
elements or the-
instruction.
Okay.
So the next count 2, we start over again with an introduction to homicide. So what I would propose is introduction to homicide would read, in count 2, Christopher Vasata is accused of first-degree murder with a firearm of Randy and Son. Where it says, or whether the killing was excusable or resulted from justifiable use of deadly force as I previously defined those terms for you. And then you can take out the justifiable and excusable on the next sentence.
Okay, so just to make sure I get what you're saying. For the initial 7.1, introduction to homicide as pertains to count 1, Your Honor will read everything.
Correct.
When we get to count 2 for Brandy El Sahi, Your Honor will read everything under introduction to homicide as it pertains to Ms. El Sahi, and then instruct them as to what he's previously read for justifiable and excusable.
Correct.
You're okay? Everybody's on the same page?
Yeah.
Pribble may not be.
No, I think so.
And Ms. Contry, can I ask you a question? And forgive me if I get it wrong on Thursday. What is the correct pronunciation of your sister's last name? El Salhi.
El Fall Key.
Thank you.
Thank you, Judge.
Okay. So Judge, we were just going over, for introduction to homicide, the first sentence will read, in count 1, Christopher Vasata is accused of first-degree murder with a firearm of Sean Henry.
Correct.
In count 2, of Brandy L. Salty. Yeah, gotcha. Okay.
So did you guys wind up saving me some reading?
Yes. You don't have to read justifiable
I
and
would say
excusable.
more, because I would renew my request on excusable homicide to eliminate paragraph 3. When a killing is committed by accident and misfortune resulting from the sudden combat of a dangerous weapon is not used, and the killing is not done including by his name. So I do not think that there's any evidence to support that. Obviously, firearms were used, and so then the definition, you take out paragraph 3 and the definition of dangerous weapon. That only applies to paragraph 3.
I'm just going to read it as is. All right. We passed the murder instructions?
I don't know that we.
On the first-degree murder instruction, I filed a motion to modify the definition of killing with premeditation.
Okay.
On page 2 of the motion, I have the requested instruction with the additions. That's a sentence and part of the sentence.
All right. I'm going to deny that request. Listen, there, a million of these cases have been tried under that standard instruction, and I'm going to stick with it. Okay. So with that ruling, are we prepared to move past the murder instructions?
I don't know. Did you?
Not on this, but we'll keep going.
Well, won't they all be the same?
Yeah, but they're not.
No, I'm hoping the state can, so
Yeah,
make,
and I can get if we can agree to what it should be for one set for Sean Henry, it would be the same for
right.
the other two.
Can I, you know what I think is going to be a good idea at this juncture, just so we can move past it? I'm going to take a 5-minute break. I want you to stand over each other's shoulder and look at this and say, this is how we want it to look. And definitely before the day is over, that everybody share the proposed packet so they can look it over, and that gives us tomorrow to fix tomorrow. Well, we don't have much time tomorrow morning to fix it, but you guys can be communicating. I usually come down and literally sit at your tables, so we're looking over each other's shoulder, but I want you to talk for a minute. I'll be back quickly so we can move past the murder instructions. Everybody can stay seated.
Okay. So now we're going on to introduction to homicide for count 2. And I changed it to, in count 2, Christopher Vasata is accused of first-degree murder with a firearm of Randy L. Sullivan. Okay.
And then that paragraph,
Okay.
if you find,
Uh-huh.
4 paragraphs down, I take away the period, and strike as I previously defined those terms. Justify
Whether, from justifiable use, or whether the killing was excusable or resulted from justifiable use of deadly force.
as I previously defined those terms.
All right, I'm going to take out justifiable homicide.
All right. Now you're going to add the interrogatories to those 3. So really, it should all be the same
As the other ones.
as the other ones, but now every time you put the term firearm, or second-degree murder on Randy, firearm is defined. And you just say a firearm has previously been defined for.
Starting with first degree or second.
I don't think there is a definition for first degree, it starts with second.
Okay. Gotcha.
It's the last paragraph.
Okay. All right. And then, so the 3, there would be 3 interrogatories for the first degree, so it would be those, not the use carry. That would go just the second and the manslaughter, which we kind of modified too.
Right, and that's not really an interrogatory, it's just
Well, the interrogatory on the manslaughter, but just the carry display a weapon.
Right.
Gotcha, okay. And so for all the ones where we have already put in what a weapon is, we'll just track the same language. A weapon has previously been defined. Okay. So where are you at now?
So now you have culpable negligence, so just take that.
Yeah, it just came out of, literally was the only one that it was on, okay. Okay, now we're at count 3.
Okay, so we'll do that first line.
Yep, and count 3. Kelly Doherty. And then the last line was after deadly force.
You're going to take out the justifiable excuse for, put in that sentence.
Yeah, the one line justify use of deadly force as,
I reduce the, what we say.
I'll find it.
Okay.
Okay. And then we'll take out.
See on next page.
That was Judith. Got it. Okay.
And then for some reason the comments came up at the very end. So just
This, yes.
free.
Just gotta make a note to myself. That was first, one second. For the second, we need to add the interrogatories as well. I don't think they're on this.
Yeah.
Interrogatories, and then,
The manslaughter. we don't
wait a minute, this
have-
one it didn't pop up with the firearm, but I guess I can just put firearm as previously,
Yeah.
okay. Okay, and then go into manslaughter.
You don't have a weapon gun, so the thing about their life.
Okay. Okay. You ready? Which one do you want now?
Now I'm on.
Okay.
There will start with 4.
Wait a minute. Here's three. Can you put his name in too as well? And it says in count 40, we just track it with Charles Wolfable.
Yeah.
Okay. This one I think we have to read with the yeah.
No, I think.
It's, the language is different. Do you want to read this one? It is, because it's attempted in there.
I guess.
Only because it does say attempted, and the other one does read as just the killing of a human being.
Yeah.
Just, okay.
But see in that fourth paragraph, 55, so deciding whether it's a temporary or permanent, we will hold 10 seconds.
So,
or aggravated assault.
okay. Or just aggravated assault. Okay. Okay.
Nobody's back there. Absolutely.
Uh-huh.
I'm going back to the first page on this one, I think.
Oh,
To the second paragraph.
going back to the first page on the introduction.
Or,
Introduction. Yeah.
okay, on the second paragraph, it starts attempted murder.
Aggravated assault. Okay.
All of which are unlawful, take down and assault, all of which are points.
All of which. That's fine.
We're still doing closings Thursday, right?
Correct.
Okay, so we're back on,
I'm here. But I cover all this up for.
and it says her too. Right before it. Gotcha.